Part 1, roles and responsibilities. So, generally speaking, trustees are people that serve on the governing body of a charitable organisation, the board, and obviously they're responsible for the general control, the management, administration, all sides, all bits of the organisation. There are different ways that trustees can be referred to, so they could be directors if it's a charitable company or a company limited by guarantee, etc. They could be board members, governors in terms of which depending on whichever setting, or many times they're just actually members of a management committee. One of the things that crops up a lot actually through POWIS, particularly in village hall settings, where village halls have been set up with a charitable object, then they tend to have lots of people who are sort of representative of organisations in the area of benefit of their charity, who are invited to send members to the committee of management. They think they're on a management committee, but they don't actually know they're trustees. So that's one of the things to watch out for, that, you know, even if you're just a management committee member, depending on how the organisation is structured, you could actually be a trustee as well. It's the role, generally speaking, not the title, that matters. So moving on. What do trustees do? Well, usually they serve as unpaid volunteers. So, you know, we're not talking about people who get paid for doing their service for their charity here. We're talking about expenses at the most in terms of any remuneration. So just covering the costs of actually being involved and serving on the charity. We are looking at people who make decisions collectively. So, you know, in terms of running the organisation, it's not one voice that's stronger than the other. It's not the chair, it's not the secretary, it's not the treasurer that has a particular amount of responsibility or a different voting rights, as it were. So we act, as a trustee, we act collectively to run the organisation. And obviously we need to put the interests of the organisation before any other consideration when we're doing so. So for me, this is a very important one. I'm the person in PAVO who gets to read everybody's governing document. I seem to sort of do that for bedside reading these days. But it is around how do organisations, what do they set up to do, and understanding what they're set up to do. And really, first principles is the governing document, which will tell you your objects, what you're actually set up to do, how you're actually set up to do it, who you're actually doing it for, etc. We'll come back into more of those sort of a terminology of that when we get to section 2. And then D, obviously trustees are the ultimate responsibility. They have the ultimate responsibility for ensuring the organisation is both well run and it's compliant with the various laws, good practice, etc. that governs or regulates the charitable sector. So, okay. Who can be a trustee? So generally speaking, it's slightly different in terms of the new CIO that's being brought in, which is the charitably incorporated organisation. But generally speaking, to be a trustee, you need to be over 18 years of age, so your age of legal responsibility, as it were. CIOs, that can actually go down to 16, but it does depend upon there being others upon the board of a certain age that can sort of validate the decision making, etc. Most people are eligible, but some are disqualified by law. So, you know, there are obviously offences that you can actually commit that involving deception or dishonesty. I wonder why deception and dishonesty is in there. Surely that can't be right. So, yes, obviously you need to be a proper person, a proper and fit person to run a charity. Anyone that's already been disqualified from being a company director or a trustee, so, you know, you've got to keep your nose clean. Undischarged bankrupt. So bankrupt is obviously, you know, somebody who has come into an arrangement with their creditors, can't pay their way, etc. So I guess you're probably clear on those terminologies. One thing to be aware of now is that new guidelines on who and who can't be a trustee are coming into force almost, you know, at the end of the month. There's not a vast amount of change. The categories above are still valid, but what it's trying to do is it's trying to actually impose some of those disqualification qualifications onto a wider cross-section. So it's not just the charity trustees, it might actually be the managers of the charity as well. So the chief execs also come under the same disqualification criteria. There's other new reasons for disqualification as well, such as being in contempt of court. So, being a liar, etc., being named under particular anti-terrorism legislation, or being on the sex offenders list. But yeah, so generally speaking also, you cannot be a trustee if you are an employee of an organisation. The idea, going back to what was previously said about trustees are not people who are paid for performing a trustee role. Therefore, you cannot actually be an employee of an organisation because you're receiving benefit from that organisation, and therefore you're setting up a conflict of interest if you are a trustee and an employee. Okay. I feel like I'm racing on, so hopefully that's okay, and I'm not rushing too much. It is quite difficult to actually get any, I can't see the whites of your eyes, but there you go. Bear with me. So trustees' roles and responsibilities. Roles a trustee can have. So trustees may take on one or more different roles. So, especially if the organisation is small, you tend to wear lots of different hats in a charity. And so obviously the first role, the primary function of a trustee is the governance role. It's overseeing from on high almost the actual running of an organisation, and that's setting the targets, setting the objectives. The day-to-day stuff is much more a managerial function. Jumped ahead. Within that governance role, obviously there is specialisation. So you might have a treasurer who is specifically looking after the finances of the organisation. Different people could be sort of focusing in on different aspects of the organisation. So you could perform a specific board role, and that might even be things along the lines of sort of HR support to the organisation, doing appraisals, doing assessments, etc. And that could be both at board level or on a subcommittee, etc. Then there's a sort of a more day-to-day management role, and this is specifically, or not specifically, this tends to happen more in terms of small charities where there is no staff, or staff need more support, etc. And so your trustee is being pulled into much more of a management role on a day-to-day basis, and that's much more of an administrative role. And finally, there is also the volunteer role. So you might actually be, you might even start off as a volunteer within your charity, actually delivering a service or helping to deliver a service to the beneficiaries of the charity, and get then sucked into being a trustee as well. So you can perform many different roles. The key issue here, I guess, is to make sure that you know which role you're actually performing at which particular time, so that you can actually park your governance role when you're doing your volunteer role. It all feeds back into that governance role, but you just need to understand that you are sort of separating yourself out as you're performing a specific function. Okay, so this is the bit where I start to frighten you now. This is about statutory duties and responsibilities. So it's there are legal and ethical issues that we need to consider. So where do these statutory duties and responsibilities arise from? Well, they arise in relation to employing staff, occupying premises, providing services, etc. So entering into sort of contracts, legal contracts. If you are a registered charity or a company, then you've got various duties that you must do in terms of reporting, whether it be to the Companies House, Charity Commission, etc. If you're a trust, then you're either administering potentially money, potentially other things, property, etc., for a particular benefit. So you have a trust that you must perform. And these are all bound and tied by various contractual duties and responsibilities. So these generally arise, as we've said. So contractual duties and responsibilities are what the organisation's governing document tells you. So it's forming basically a contract between the organisation, its members, and its beneficiaries. It is a contract between you and the people that you're seeking to help in terms of how you go about delivering things. This is why I tend to bang on about governing documents quite a bit, because it's the basis from which all organisations are formed. it's quite eye-opening. And when I'm doing this training session in a live environment, when I have people around me, I've asked people before now to bring in their organisation's governing documents so that we could actually go through them and have a sort of a discussion around some of the various clauses within them. Interesting things have cropped up in the past. Organisations that have a number of trading outlets that have a bar to actually doing any permanent trading written into their constitution. Had one organisation that actually didn't know whether they'd sent their trustee with their current governing document or one that had been updated. So, these things can get lost sight of quite easily. They can sit in a drawer somewhere. They can not be read. New trustees, did they receive copies of the governing document which help them to understand why they're there or how they're there or what the organisation's supposed to do? There are also, moving on to B here, there's also legally binding agreements with third parties. So if you enter into a lease, that's a legally binding contract. There are penalty clauses if you come out of that lease early. You're contracting with employees, you're creating legal situations, etc., whereby you are responsible as trustees to actually make sure that they are delivered as you said they would be delivered, or as you entered into a legal agreement to deliver them. And that's the same with goods and services. And we'll come on a bit later in terms of looking at incorporation and liability and things like that, which apply particularly to things like leases as well. Okay, so that was looking at statute. So that statute law is there's a whole body of laws passed by government, etc., that sit on the statute books and sort of require organisations to work in a certain way. Another area that you need to abide by is sort of common law duties and responsibilities. So these arise from decision of the court, so the case law that's built up over many, many years. Sort of an example of that is if an organisation is trying to form a new charity that is using purposes that have never been agreed before by the courts or by the Charity Commission, you're almost developing case law as you go and actually agreeing those purposes for the new charity. Obviously, for charities particularly, there's charity and trust law. So the Charities Act 2011, Trustees Act 2000 all set out the way that charities should operate. And within that as well, obviously, if it's set up in law, then there is sanction in law as well if you don't actually abide by the responsibilities that are laid out in these documents. And on top of that, there is the whole sort of reputational side. So not just the legal side, but the reputational side of being a trustee. And that is making sure that you abide by good practice, by the prevailing opinions in the sector. You may or may not have come across something called the Charity Governance Code, which has been agreed and developed both by the Charity Commission and other actors. So I think the Society of Chairs, the NCVA organisations in covering the whole of the voluntary sector across the UK have come together and agreed a new sort of best practice guidance called the Governance Code. And really that's about getting charities to sort of sign up to and agree to follow best practice and to constantly try and look at themselves and the way that they do things. So there is a sort of an onus upon trustees to do good practice, to do things better and better. And then there's the moral obligation side of things, whereby, after all, you are a charity, therefore you have been set up to do things for the benefit of others, and you tend to make promises in doing that. And just forming the organisation is a promise to your beneficiaries that you will act in a certain way. You might be making promises to people who are donating to your good cause. And it could well be that there's other principled beliefs which guide the organisation's actions depending on the reasons for which they were set up. That whole area looks primarily towards the reputation as well of the sector. A lot of the things that organisations such as regulators such as the Charity Commission look out for is the impact of bad practices upon the confidence that the public hold in the charity sector, and that's been rocked a lot recently by Oxfam scandals, Save the Children scandals, etc. charities have to be seen to be whiter and white just to encourage people to still invest their trust in them, and obviously be prepared to actually donate to the sector. So you can't do anything without that sort of trust that that is built by good practice and by sticking to your moral obligations. I'm just going to take a very quick drink as I'm drying up, and then we'll move on to something a bit meaty, which is liability of trustees. Sorry if that sounded loud in your ears. Okay, so personal liability. What are we talking about? So if trustees act improperly, they may be personally responsible for the liabilities incurred by the charity, or they might be responsible for making good any losses to the charity. Generally speaking, when we're talking about improper conduct, it's very rarely that it's willful or something that somebody has set out to do or charities have set out to do. It's things that have happened because they've come adrift from their governing document. They don't understand what powers they have in terms of running their charity, and they go and do something that is ultra vires, beyond powers, etc. Ignorance is no defense in law, needless to say. So you just have to be very, very sure that when you're acting, and the reasons that you're acting are in the best interest of the charity, but also fit to your charity's governing document. Trustees, again, just restating the point, as trustees act collectively in running a charity, they are usually collectively responsible to meet any such liability. It was an interesting case, actually, just to get into the financial side of things. I believe it was a golf course. A golf course had entered into a contract with a builder for certain repairs. They thought it was a fixed price contract that they'd entered into, and they'd agreed an amount that the repairs were going to run to. The builder had other ideas, and there was about £20,000 discrepancy over and above the cost that the charity was going to pay. And the builder basically sued each and every member of the trustee body. He wasn't suing them for any particular amount. They were suing them for the recovery of the whole amount. Each member of the trustee body was being sued for the missing 20,000. As soon as the first case was won, and it was actually against the chair of the charity, so he got his 20 grand, the builder, from the personal assets of the chair. Then it gets to the stage of, well, the chair is only one member of that actual organisation, and the chair then almost has to go and sue the other members of the trust body to recover an equal share from each of them because they were all responsible for the decision. So that's frightened you, probably. So how do you actually limit this? Well, obviously, it's to sharpen your mind. It's to make sure you understand what you can actually be liable for, and that you make those decisions collectively, that you are actually paying attention and not allowing a strong person on the board to make those decisions without having them properly discussed. Okay, so what can you be liable for? So breach of trust or duty. So that is where you have basically gone beyond what you've been set up to do. You're acting outside the powers of the governing document, or, clearly the most obvious one, you're carrying out fraudulent or wrongful trading. You're sharp practicing, as it were. Carrying out unpermitted political activity. Charities have to be very neutral and have to be very careful in terms of how they're perceived as well, let alone what political activity they might be doing. There's been a lot of pressure on charities presently, actually, in terms of where they are being perceived to stray into political activity, and it's a bit of a minefield, as you can imagine, because the way politicians tend to be, and the sensitivity to criticism. So even if you're campaigning for something that is very much a social wrong, then you could be straying into political territory. So how do you actually make sure you're actually perceived being sort of very apolitical in terms of what you're doing? Obviously, receiving personal benefit as a trustee. So we'll come on to that here in terms of conflict of interest as well, because to a certain extent, that's what conflict of interest is all around. Obviously, acting as a trustee director when disqualified, and failure to comply with statutory requirements. So that is, mea culpa. I'll put my hand up on this one. I have been, not to a charity, but I've been secretary to a company limited by guarantee, working in the voluntary sector, it's a local development organisation, and I managed to forget to send in a confirmation statement for that company. So I've done the same with the accounts. I didn't forget to send the accounts in on time. I managed to send the accounts in minus the signed page, which I'd left on the photocopier. And the company's house is, shall we say, not very understanding of these matters, and promptly issued a £600 fine, which, you know, ouch. So, you know, there are things that hit you if you're not careful, if you don't pay sufficient attention. And going back to my confirmation statement, I am not a trustee of that. I was rather not a director of that organisation. I was just a volunteer. I was actually doing stuff as a sort of a volunteer secretary for the organisation. And I managed to forget that the confirmation statement was due in March. I got into my head that it was due in May, and I hadn't checked my emails to receive on the particular account that the company receives emails. So I'd missed the reminders. And the first I knew about it was when registered letters started arriving for all the trustees, or all the directors rather, at the registered address of the company, which went down well, as you can imagine. But that's what we're talking about. You've got to actually comply with your statutory requirements, or else, basically. You know, there was lots of threats from Companies House within those registered letters that went out, in terms of the potential fines to the directors, etc., you know, exclusion from being directors, etc. And if you've got people who are directors of other companies, etc., it can be quite a shock. Lots of etceteras in that statement. I shall try and give up on those. Okay, so moving on, reducing the risk of personal liability. Right, what is it unlikely you will be held personally liable for? So, or rather, you will be, I'll start again. It is unlikely you will be held as personally liable if you, oh, I've lost it, there we go, act reasonably, properly as a trustee. So the key issue here is that you've got to be seen to be acting properly. You've got to have minuted meetings, etc. You've got to be showing a process. If you can show that your process is fully considering the issues, is actually referring to your government document, is taking legal advice if you need to, then you are acting reasonably and properly as a trustee. Things can still go wrong, but if they do, under those instances, you're unlikely to be seen as being liable. Yeah. You need to comply with your organisation's governing document. These are points that I've already sort of covered. I'll give you an example of this, naming no names, but a community centre in Paris was set up with just straight village hall trusts. Basically, it was there to run a village hall that was attached to a school. At some point along the lines, somebody got into their head that it would be good to also take on a lease for the recreation ground that sat next to the community centre. And then to improve the recreation facilities, they thought, well, let's buy that adjacent piece of land and sort of put all-weather pitches on there, put various bits of infrastructure on there. And they entered into various contracts to provide that infrastructure, and those contracts ended with them having about £20,000 worth of debt that they were paying off over sort of on a repayment schedule with one of the organisations that actually assisted them to put this infrastructure in place. Only, of course, that they were a village hall trust and they'd had no powers to do any recreation activities, and basically that debt was the responsibility of the trustees who acted beyond those powers. So, shall we say, there was a bit of a mess. We had to advise the trustees of the village hall that were currently operating that if they actually continued to service that debt, they would be acting beyond the powers of the organisation as well and would be personally liable. So you can get yourself into all sorts of difficulties if you start to stray away from what you've been set up to do. Finally, take appropriate professional advice when you don't know enough to make a decision. Never be too proud to actually ask proper advice. Hopefully, if you're a charity, you can get that advice pro bono or in ways that do not cost the charity huge amounts of money, but to a certain extent, if the decision is that vital that you need to spend a bit of resource to make sure that you're acting legally and professionally, then it's well worth doing that, because otherwise, you could be picking up the mess many years hence. Okay. So reducing the risk collectively. Again, just emphasizing the fact that trustees are all created equal and should operate equally. They should take decisions in collectively, etc. So the collective responsibility that you have, therefore, is to make sure your charity has good management practices, has clear roles and responsibilities. If you're doing more than just an overview governance role, if you're actually doing working with staff, working with your beneficiaries, etc., make sure that the roles and responsibilities of who's designated to do what are clear. Ensure that there's accurate record keeping. That's not just financial records, that's also minuting of decisions. Keep a good and comprehensive record so you can see what's been decided, how it's been decided. We'll come on to that again also in terms of the conflict of interest side of things. Make sure you have a bit of slack, a bit of contingency funds that you've planned for things that might happen, things that might not come off. Easier said than done, perhaps, but you need to try and build that into what your thought process is in terms of taking your charity forward. Always seek professional advice. That could be, to a certain extent, even if it's sort of entry level advice, such as perhaps Pavo can give, in terms of we've got plenty of built up information and experience and case history, I guess, that could be useful to any charity before you actually go down the route of a legal advisor. And I would state as well, in terms of any legal advice that you take on, bear in mind not every lawyer is a charity expert, etc. There are, there's law and there's law. Board development. This goes back to that charity code. It goes back to sort of always making sure that when people come on board as trustees, they're given the opportunity to come on training such as this, or the expanded version that we do, that they're actually given a copy of the governing document, that they're actually sort of mentored even within the role to start with by a member of the board. You can also take out liability insurance as well. So that's obviously, you've heard of your public liability, but there's also a professional liability insurance that you can take out. A word of caution there, of course, is that, you can insure for certain things, but you can't insure for, coming away from your governing document. If you are acting irresponsibly as a trustee board, then no insurance in the world is going to cover you.